I'd like to thank the Permanent Bureau and particularly Jerry for inviting me to participate in this panel today. Israel is not a signatory to the 1996 Convention on Child Protection. However, we are signatory to the 1980 Hague Abduction Convention. And I would like to address the interplay between the two, and by using a case that is currently being litigated in Israel to attempt to demonstrate how the 1996 Convention's adoption could enhance and simplify proceedings that are brought under the Abduction Convention for the return of an unlawfully removed or retained child. The case that I'm referring to involves a tragic incident that occurred in Italy with an Israeli family. Let me preface by saying that the case has been extensively covered both in the Israeli and Italian press, so I'm not divulging any information that is not already in the public. The family had originally from Israel moved to Italy approximately 1 month after the birth of the child in question and had been living there for the past 6 years. Several months ago, there was a tragic accident where a cable car that the entire family was riding on was involved in an unfortunate accident, and all of the family, except for the 6-year-old, perished in the fall of the cable car. Now, the 6-year-old who survived the accident remained, of course, in Italy, was hospitalized there, and his Israeli aunt, who also was living in the same village in Italy nearby the family, asked the court for temporary custody in order to continue to care for the child. And the court in Italy granted the aunt that temporary order. Included in the arrangements of her temporary custody were the access that was granted to the child's grandfather who lived in Israel. The Israeli grandfather, on a visit to Italy, had taken the child in the morning as agreed upon, but at the end of the day, instead of returning him to the aunt, decided to take him on a private chartered flight, which he had arranged in Switzerland, crossed the border to Switzerland, returned him to Israel, and stated that he was now returning the child to his home. The aunt, who got wind of what happened, filed an application under the 1980 Hague Abduction Convention for the return of the child to Italy. Now, as a matter of full disclosure, I do not represent any of the parties in the case, but I have been consulted by the attorney retained by the mother on an informal basis. Once the petition was filed in the court in Israel for the return under the 1980 convention, the petitioning aunt also went to the court in Italy and asked for an Article 15 decision under the 1980 Abduction Convention. Now, for those of you who recall the Article 15 provision, it's basically a non-binding opinion of the Court of Habitual Residence that states that the child had been habitually resident in that state's jurisdiction at the time of the removal, and therefore the removal was contrary to the law of that jurisdiction, in this case, Italy. Now, again, as I said, this is a non-binding opinion of the court. It's generally obtained on an ex parte basis. However, courts tend to give credit to those opinions, but they are not obligated to. Once the petition was filed in Israel, the grandfather responded in a number of ways. First, he claimed that because the child had lost both parents, there was no one to determine the habitual residence of the child. And therefore, the fact that the aunt was given temporary custody was contrary to the proper application of Italian law. And in order to support this contention, he filed legal opinions of Italian law professors claiming that the court acted beyond its jurisdiction in Italy in granting the temporary orders to the aunt of guardianship. In addition, the Italian legal professors stated that the Article 15 decision was not properly rendered, given that there was no habitual residence at the time of after the time of the death of the 6-year-old's parents. Now, obviously, I'm not getting into whether or not the contentions had any basis, but I'm using this as a way to show that procedurally, the 1996 convention could probably have assisted in simplifying the return petition. And how so? Well, first, we start with Article 50 of the 1996 convention, which states that nothing precludes the provisions of this convention from being invoked for purposes of obtaining the return of a child who is wrongfully removed or retained. So we learned from Article 50 that the 1996 convention works in conjunction with the 1980 convention and is not an either-or proposition. Now, in what way would the 1996 convention assist us in this specific instance in order to shorten and simplify the proceedings that are presently being conducted in this case? Well, Article 23, Article 23.1 of the 1996 convention states that any decision issued by the state of habitual residence, which is also a party to the convention, would automatically be recognized by operation of law in the requested state. So unless there were one of the grounds for refusal under Article 23.2, which we assume in this instance would not exist, the Italian order granting temporary guardianship to the aunt would automatically become an Israeli order, so that the issue of whether or not the order were properly rendered under Italian law would become moot, and along with it, the need to get legal opinions from Italian legal experts. The other issue that would be relevant here would be covered by Article 25 of the 1996 convention, which states very clearly that the requested state would be bound by the findings of fact of the requesting state in making a judicial determination. So in our case, the findings of fact under the Article 15 opinion would no longer be simply an opinion. They would become binding facts on the Israeli court. Once the determination in the Article 15 petition that the child had been unlawfully removed from Italy were now binding facts on the Israeli court, there would be no possibility for the Israeli court to now try and determine whether or not that removal were unlawful or contrary to the laws of Italy. In order to invoke the 1996 convention, I believe that you could do it in parallel to the 1980 convention, because the 1996 convention itself provides that it is a way of assisting the return of a child and not as a matter of being exclusive in the use of these proceedings. So because of the fact that Israel is not a signatory to the 1996 convention, the case in the matter of this 6-year-old child has taken some very unusual turns, creating midnight hearings in family court in Israel, arguing over legal experts from Italy as to whether or not the Italian court had acted properly and within its authority. While under the 1996 convention, these proceedings would not have been taking place, and we would have probably had a decision by now. So it's my hope that someday the 1996 convention will be ratified by Israel. I know that it's being considered at this time, and hopefully we will sign on to it soon. But until it does, unfortunately, we will not be able to benefit from some of the provisions which could help us simplify abduction or unlawful retention petitions that are being heard here. Thank you very much for your attention, and I look forward to our next in-person proceeding and conference. Thank you.